There is a moment in every courtroom when the air hardens, when the law stops being theory and becomes a blade. I had presided over thousands of cases, but I had never felt it like this. Because on that Thursday afternoon, standing beneath the seal of the court, Barron Trump crossed a line no defendant in American history had ever dared to cross. He didn't shout. He didn't rage. He promised. He looked me straight in the eye, 18 years old, 6'7" of inherited confidence, flanked by Secret Service agents, and calmly informed me that if I did not dismiss his charges, his father, the sitting President of the United States, would make phone calls, and I would regret it. I had been threatened before. Every judge has. Desperate men swear revenge. Cowards name-drop friends they don't have. This was different. This was the son of Donald Trump, still occupying the Oval Office, standing in my courtroom, as if it were already his inheritance. The charges alone were serious: assault, destruction of property, underage drinking. According to police reports and sworn testimony, Barron had attended a house party in Providence hosted by a Brown University student whose parents were major Trump donors. Alcohol flowed. Tempers followed. When a 19-year-old sophomore, Michael Chen, accidentally spilled a drink on Barron's designer jacket, Barron responded with a punch that shattered the young man's nose. When Michael tried to record the assault, Barron grabbed his laptop and smashed it against the wall. But none of that, not the blood, not the broken bone, not the destroyed future, was what turned this case into history. It happened after I denied the motion to dismiss. Barron's attorney had barely returned to his seat when Barron stood up himself, brushing past frantic hands trying to pull him down. "Judge," he said, his voice smooth with certainty, "you need to understand something. My father is the President of the United States. Right now, today. He has power that changes lives. He can make you famous, or he can make you disappear." Silence swallowed the room. Keys froze above laptops. Secret Service agents shifted, uneasy. His attorneys went pale. "Dismiss the charges," Barron continued, "or you'll find out exactly what presidential power means." In that instant, the courtroom stopped being a room. It became a battlefield between branches of government. If judicial independence meant anything at all, this was the moment it would be tested. I leaned forward slowly. "Mr. Trump," I said, my voice steady enough to cut glass, "before we address your criminal charges, we are going to address what you just said. You have threatened this court with presidential retaliation. Do you understand the gravity of that?" He smiled. Not cocky, assured. "I'm not threatening you, Your Honor. I'm stating facts. My father protects his family. You're deciding right now whether you're someone he protects or someone he doesn't." His lead attorney shot to his feet. "Your Honor, my client is under extreme stress." "Sit down," I said. "Your client meant exactly what he said." I turned back to Barron. "I will give you one opportunity," I said. "Retract your statement and apologize to this court. If you do, we proceed with your criminal case. If you don't, I will hold you in contempt and add charges of witness intimidation and obstruction of justice." His lawyers silently begged him with their eyes. Barron looked at them, then back at me. "I'm not apologizing," he said. "My father runs this country. He picks judges. He can unpick them too. You think you matter? One call to the governor, one call to the state Supreme Court, and you're finished." The room erupted. Typing, whispers, radios crackling. And in that chaos I realized something chilling. This wasn't a teenager lashing out. This was a doctrine, a belief that power erased consequence. I stood. "Officer D'Angelo," I said, "place Mr. Trump under arrest immediately for criminal contempt of court, witness intimidation, and threatening a judicial officer." Barron's face drained of color. "You can't arrest me," he said. "I have Secret Service protection." I turned to the agents. "Your duty is to protect him from harm," I said. "Not from the law. If you interfere, you will be charged with obstruction of justice." 30 seconds passed that felt like a lifetime. Then the lead agent stepped back. "We will not interfere with lawful judicial proceedings." The handcuffs came out, and as they closed around the wrists of the president's son, the unthinkable became real. America was about to find out whether its constitution was stronger than its most powerful family. The handcuffs clicked shut with a sound too small for what it meant. Metal on skin. Privilege meeting consequence. For a heartbeat, Barron Trump didn't move. His eyes darted around the courtroom as if someone, anyone, would stand up and stop this. No one did. Not his lawyers. Not the Secret Service. Not the power he had been raised to believe was automatic. "This is illegal," he said louder now. "You're violating my rights. My father cannot help you here," I cut in. "Not today." Officer D'Angelo guided him toward the side door. The path to the holding cells had never carried someone like this before. Cameras flashed. Reporters leaned forward as if witnessing a crack in the sky. "Call the White House," Barron shouted. "Call my father. He'll shut this down." I watched him go, the certainty draining from his posture with every step. This was the first time in his life the Trump name had failed to open a door. When the door slammed shut behind him, the courtroom did not erupt. It froze. The silence that followed was heavier than shouting, because everyone understood the same thing at once. Something irreversible had just happened. "Counsel," I said, turning to his lead attorney. "Your client threatened this court with presidential retaliation, twice. That ISW is not emotional distress. That was intent." "Your Honor," the attorney said, voice tight, "this has escalated beyond state jurisdiction. We request an immediate recess." Denied. I looked toward the prosecution. "Ms. Chen," I said, "contact the Rhode Island Attorney General immediately. Inform him that the president's son has been arrested for threatening a judicial officer. Also contact the FBI. Threatening a judge, especially with executive power, raises federal concerns." She was already dialing. The Secret Service agents stood rigid now, no longer shields of authority but witnesses to it unraveling. Their lead agent met my eyes. "Your Honor," he said carefully, "how do you wish us to proceed?" "You will maintain protective custody," I replied. "Nothing more. No favors. No interference." He nodded once. Grim, professional, powerless. And then, quietly, almost forgotten in the storm, I saw him, Michael Chen, the victim. He sat in the second row, hands folded, nose still bandaged, eyes wide not with fear, but disbelief. He had walked into court expecting excuses, delays, influence. Instead, he had watched the unthinkable unfold. I motioned him forward. "Mr. Chen," I said gently, "I want you to know something. What just happened does not erase what was done to you. Your case will be heard. Fully." He swallowed and nodded. "Thank you, Your Honor." His voice shook, not from weakness but from relief. Behind us, reporters were already sending alerts. Phones buzzed across the room. Somewhere, aides were running down White House hallways. Somewhere else, constitutional lawyers were opening books they never thought they'd need. Because for the first time in modern history, the justice system had put handcuffs on the living symbol of presidential immunity. And everyone knew what came next. The backlash, the phone calls, the threats dressed as concern. As I adjourned the session, one thought settled cold in my chest. If the president chose to intervene now, this would stop being a criminal case and become a test of whether American democracy could survive direct executive intimidation. The storm didn't wait for nightfall. It broke before the courtroom benches had cooled. Within an hour, every major network carried the same headline in different shades of disbelief. "President's son arrested after threatening judge." Phones in the clerk's office rang without pause. Legal analysts crowded studio panels. Former prosecutors leaned forward, speaking in the hushed tones reserved for moments that might rewrite textbooks. And then, as if on cue, the response came from the top. A tweet, sharp, immediate, unmistakable, from Donald Trump himself. "My son Barron was illegally arrested by a rogue judge. This is a political hit job. The deep state is attacking my family. Barron did nothing wrong. We will fight this witch hunt." The word spread faster than the law ever could. By sunset, protesters gathered outside the courthouse, some chanting for justice, others waving flags and shouting my name like it was an accusation. Police barricades went up. Security doubled. The building that had been designed for quiet deliberation now felt like a bunker. Inside my chambers, I sat alone, reading the tweet again. Not for anger, but for implication. Because that wasn't a father defending a son. That was the President of the United States publicly undermining a judicial arrest. And that mattered. My phone rang. Judge Caprio, a measured voice said, "This is the Attorney General of the United States." I closed my eyes for a moment before answering. "Yes, General." "The President is concerned," he said carefully. "There are discussions underway about possible executive remedies should this situation escalate." "Executive remedies?" I repeated. "Pardons," he said, "for any potential federal exposure." I leaned back in my chair. "General," I said, "Barron Trump is charged with state crimes in Rhode Island. Assault, destruction of property, criminal contempt, threatening a judicial officer. The President has no authority to pardon state charges." "I understand that," he replied, "but the President believes his son's constitutional rights are being violated." "The President's son threatened me in open court," I said. "On the record, if the President attempts to interfere with this prosecution, directly or indirectly, that is obstruction of justice." There was a pause, not confusion, calculation. "I will relay your position," the Attorney General said. "Please do," I replied. "And make sure the President understands this clearly. Judicial independence is not optional, not for him, not for his family." The call ended. Outside, the chants grew louder. Inside a holding cell a few floors below, Barron Trump sat on a steel bench, no cameras, no suits, no Secret Service buffer, just concrete walls and the weight of a reality he had never been taught to imagine. That night I reviewed the file again. The assault photos, the broken laptop, the witness statements, the video Michael Chen had tried and failed to save. This wasn't politics. This wasn't vengeance. This was a criminal case that had collided with power. And 3 days later, when Barron was brought back before me for his expanded bail hearing, the country held its breath. Because if I bent now, the message would be clear. Threaten the judiciary hard enough, and it will flinch. I looked down at the bench copy of the Constitution as the courtroom filled, and I knew, absolutely, that the next ruling wouldn't just decide a boy's freedom. It would decide whether the law still ruled the powerful or whether power had finally learned how to rule the law. The bail hearing began under a sky thick with cameras. By dawn, satellite trucks lined the street like armored beetles. Inside the courthouse, deputies checked badges twice. The metal detectors hummed without rest. Every seat was filled. Reporters, law students, retired judges, citizens who sensed they were about to witness a hinge point in history. When Barron Trump was brought in, the room shifted. The orange jumpsuit swallowed him. The tailored confidence was gone, replaced by something fragile and unfamiliar. He didn't look powerful now. He looked young and terrified. His eyes searched for his attorneys, then for the Secret Service agents, still present, still silent, still unable to save him from what mattered. "Court is in session," the clerk announced. Mr. Lawson rose first, voice rehearsed but tight. "Your Honor, we move for immediate release on bail. My client has no prior criminal history, poses no flight risk, and is under constant federal protection. Furthermore, we submit that the events leading to his arrest demonstrate judicial bias, warranting dismissal or recusal." The word bias landed like a match near gasoline. I waited, let it burn out on its own. "Counsel," I said, "your client threatened this court with presidential retaliation, twice, on the record. I responded by enforcing the law. That is not bias, that is duty." Lawson opened his mouth again. "Sit," I said. He sat. I turned to the prosecution. "Ms. Chen." She stood. "Your Honor, the defendant is charged not only with assault and destruction of property, but with criminal contempt, witness intimidation, threatening a judicial officer, and obstruction of justice. He has demonstrated a belief that executive power can shield him from consequence. That belief makes him a flight risk, regardless of age or protection. I looked at Barron. "Mr. Trump," I said, "you told this court that your father runs this country. You said he could make judges disappear. Do you stand by those statements?" His voice cracked. I was scared. I didn't mean—" "You meant exactly what you said," I replied softly. "You said it twice." A murmur rippled through the room. "Here is my ruling," I continued. "Bail is denied." The words landed hard. "Final. Mr. Trump, you will be remanded into custody pending trial. Your resources are unlimited, your access to influence is unparalleled, and you have shown contempt for the judicial process itself. Under these circumstances, detention is necessary to protect the integrity of this court." Barron's shoulders slumped. For the first time, he didn't argue. Outside, the reaction was immediate. Outrage on one side, applause on the other. Somewhere in Washington, phones rang again. Within minutes, another statement appeared online from Donald Trump, shorter this time, sharper. "This is an attack on my family and my presidency. We are reviewing all options." All options. I closed the file and rose from the bench, knowing exactly what that phrase meant. The pressure was coming next. Quiet calls, back-channel warnings, offers disguised as concern. Because if the president chose to push, really push, this case would stop being about bail. It would become a direct confrontation between the Oval Office and the rule of law. And as the guards led Barron back toward the holding cells, I realized the truth settling in my bones. The hardest part wasn't denying bail. The hardest part was still ahead. Pressure doesn't always arrive as a threat. Sometimes it comes as concern. The morning after the bail denial, my chambers filled with voices that smiled while they warned. Former colleagues called just to check in. Party officials spoke in careful hypotheticals. Even a retired judge, someone I had once admired, left a voicemail suggesting I consider the broader national consequences. No one asked me to release Barron outright. They asked me to pause, to reconsider, to let cooler heads prevail. That was how power worked when it learned it couldn't shout. By noon, I received a sealed motion from the defense, an emergency filing requesting my immediate recusal, alleging that my refusal to grant bail constituted personal animus toward the Trump family. I read it once, then again. It wasn't law. It was pressure wearing a robe. I denied the motion without a hearing. "Recusal," I wrote, "is not a shield against accountability. The defendant's own words created this circumstance. Judicial enforcement of the law does not constitute bias." When court reconvened, the room felt tighter, like the walls were leaning in to listen. I called the next witness. "Mr. Michael Chen," I said, "please take the stand." He walked forward slowly, the bruise beneath his eye now fading to yellow, his posture careful, measured. The oath trembled slightly in his voice, not fear, but gravity. "Tell the court what happened," I said. He inhaled. "I spilled a drink," he began. "A few drops. I apologized immediately. I offered to pay. Barron looked at me and said the jacket cost more than my family made in a year." The courtroom stilled. "Then he punched me," Michael continued. "I fell. My nose broke. I tried to record because I was scared. He grabbed my laptop, everything I owned for school, and threw it against the wall. When it shattered, he said, 'I can do whatever I want. My father is the president.'" A breath caught somewhere in the gallery. "And then?" I asked. "He kicked me while I was on the ground," Michael said quietly, and walked away. Defense counsel objected, weakly. I overruled. Michael looked at me then, eyes steady. "Your Honor," he said, "I came to this country when I was 10. My parents saved for years so I could study here. I believed the law protected people like me. After that night, I wasn't sure anymore." I felt something shift, not in the room, but beyond it. This was no longer a story about privilege embarrassing itself. This was about whether the law still spoke for the voiceless. When Michael stepped down, the courtroom remained silent. Not because people were stunned, but because they understood. That evening, A new phrase began appearing on cable news banners: judicial independence under siege. And then came the whisper that changed everything. A senior congressional aide leaked to the press that if the president interfered any further, formal impeachment discussions would begin, centered not on policy, but on obstruction of justice. I read the headline once, then closed the paper, because I knew the truth the cameras hadn't caught yet. If the president crossed the line now, this case would no longer belong to the courts. It would belong to history. And the next move wouldn't be mine. Power hates silence most of all. After Michael Chen's testimony, the noise outside the courthouse grew sharper, more desperate. Supporters shouted about witch hunts. Critics spoke of accountability. But inside the system, where real damage could be done, everything went quiet. Too quiet. 3 days passed without a word from the White House. No tweets, no statements, no denials. That kind of restraint didn't signal surrender. It signaled strategy. On the fourth morning, a federal courier delivered a thick envelope marked confidential. Inside was a notice. The defense was petitioning to elevate jurisdictional review, arguing that the presence of Secret Service, presidential security concerns, and executive implications required federal intervention. It was elegant, dangerous, and intentional. If the case moved or stalled in the wrong hands, justice wouldn't be denied. It would be dissolved. I scheduled an immediate hearing. When Barron Trump was brought in, he no longer looked angry or afraid. He looked hollow. The bravado was gone. So was the certainty that someone would rescue him. "Mr. Trump," I said, "your counsel has filed a motion suggesting this court lacks authority due to your father's position. Do you agree with that motion?" He hesitated. "I just want this to stop," he said quietly. "That," I replied, "is not an answer." His attorney rose. "Your Honor, we contend that continued detention risks national security complications and executive disruption." "Denied," I said, before he could finish. "This court does not surrender jurisdiction because a defendant's last name creates inconvenience." A murmur rolled through the gallery. I leaned forward. "Let me be clear," I said. "There is no constitutional doctrine that places the president's child above state criminal law. None. If such a doctrine existed, democracy would already be dead." Barron's eyes met mine then, not with defiance, but confusion. "But, my father said—" He stopped himself. I waited. "He said things would be handled," Barron finished. "And now?" I asked. He swallowed. "Now he hasn't called." That truth landed harder than any ruling, because for the first time, Barron Trump understood something devastating. Power protects itself first. I adjourned the hearing and returned to chambers, where another message waited. This one unofficial, passed quietly through intermediaries. The president was exploring options. Congress was monitoring developments. Advisors were divided. Translation: the system was shaking. If Donald Trump intervened now, it would trigger hearings, subpoenas, testimony under oath. If he didn't, his son would face trial like any other defendant. There was no clean exit left. That night, I reviewed the charges one final time before setting the trial date. Assault, destruction of property, criminal contempt, witness intimidation, threatening a judicial officer, obstruction of justice. A case that had begun with a spilled drink had become a constitutional reckoning. And as I signed the order, one thought followed me into the quiet. The next decision wouldn't be made in a courtroom. It would be made in the Oval Office. The Oval Office chose silence. For 48 hours after the hearing, there was no statement, no tweet, no midnight fury typed in all caps. Advisors leaked contradictions. Allies hedged. Enemies sharpened knives they'd been waiting years to use. And in that silence, something extraordinary happened. The law began to move on its own. A bipartisan group in United States Congress quietly requested preservation orders, emails, call logs, internal memoranda, anything that might show whether pressure had been applied to influence a state prosecution. Not an investigation yet, something colder, preparatory, the kind that signals inevitability. I learned this not from the news, but from a late-night call. "Judge," the voice said, careful and anonymous, "you should know there's concern on the Hill. If the president intervenes, even indirectly, this won't stay hypothetical." "I'm aware," I replied. "You might want to document everything." "I already have," I said, and hung up. The next morning, the defense made its final gamble. A plea proposal, quiet, conditional, and revealing. Barron would plead guilty to reduced charges. No trial, no testimony, no spectacle. In exchange, the prosecution would recommend a limited sentence with credit for time served. The offer was framed as mercy. It was, in truth, a retreat. When Barron Trump was brought in to discuss it, he didn't look relieved. He looked ashamed. "They're saying this is the only way," he said, staring at the table. "That if it goes to trial, it gets worse." "For whom?" I asked. He didn't answer. His attorney cleared his throat. "Your Honor, my client accepts responsibility. He wishes to resolve this matter without further damage to—" "To what?" I asked. "The country? Or the family?" The attorney paused. That was answer enough. I addressed Barron directly. "This is your decision," I said. "Not your father's, not your lawyer's, yours. If you plead, you accept guilt publicly. If you go to trial, you face everything that comes with truth." He nodded slowly. "I thought power meant protection," he said. "I didn't know it meant abandonment." The words were barely audible. They didn't need to be louder. I granted a brief recess. Outside the courtroom, cameras waited. Inside, the machinery of consequence continued turning, methodical, indifferent to names. When court resumed, the plea was entered. Guilty. The word echoed longer than it should have. As I accepted it, I felt the tension in the room shift. Not release, but redirect. The crisis wasn't over. It had merely changed shape. Because a guilty plea closed one door, easier, and opened another. If the president had stayed silent to avoid catastrophe, that silence would now be judged. And if he broke it after this point, it would be seen not as defense but as interference. As Barron was led away once more, he looked back, not with anger this time, but with something like understanding. And I knew then, the case against the son was ending. The reckoning for the father was just beginning. Silence is never empty. It carries weight. It chooses sides. For 48 hours after the plea, the White House said nothing. And in Washington, nothing is louder than that. No midnight tweets, no fiery press briefings, no outraged surrogates flooding the networks. Just absence. And absence, when it follows a threat, becomes evidence. Inside the courthouse, the machinery of law continued without ceremony. Filings stamped, motions logged, orders signed in ink that did not tremble. The case against Barron Trump narrowed, sharpened, became finite. A son's guilt had been acknowledged. A sentence awaited. But beyond these walls, something far more dangerous was forming. Phones rang in offices that pretended not to listen. Staffers whispered in hallways built for power, not truth. Congressional aides requested document preservation, quietly, politely, the way one asks before a storm breaks. Not an investigation, not yet. A readiness. Because everyone understood the same unspoken rule. If the president spoke now, it would not be protection. It would be interference. And interference leaves fingerprints. I felt it that morning when I opened my chamber's door and found no crowd, no protesters, no chants. Just officers standing straighter than usual. Eyes alert. The kind of posture men adopt when history might walk past them unannounced. Inside, Barron was brought in once more. He no longer looked like the heir to anything. The jumpsuit hung loose. The arrogance had evaporated. What remained was 18 years of inherited certainty collapsing under the weight of consequence. He didn't meet my eyes at first. "Mr. Trump," I said, "do you understand the plea you've entered?" "Yes," he replied. His voice didn't echo anymore. "Do you understand that no one, no office, no title, no bloodline, can undo it?" He nodded, slowly. "I thought—" He stopped himself, then tried again. I thought power was permanent. That was the lie every fallen dynasty believes. Outside the courtroom, the press waited for spectacle. They wouldn't get it. Justice, when it finally arrives, is rarely dramatic. It's quiet, procedural, almost boring. And that terrifies power more than outrage ever could. By afternoon, word filtered in from Washington through channels that never leave paper trails. The president was being advised to remain silent. Any comment could complicate matters. Any action could invite scrutiny. For the first time, executive power had met a boundary it couldn't threaten away. Because this time, the threat had been recorded. As Barron was escorted back toward custody, he paused at the door. Not defiant, not angry, just awake. He turned once, just once, and our eyes met. There was no apology in his expression, only understanding. The kind that arrives too late to save you, but just in time to change you. The gavel fell. And in that sound, I heard something far louder than metal on wood. I heard restraint. The Oval Office had chosen silence, and in choosing silence, it had admitted something it never intended to confess. Power could no longer move this case. Only the law could. Power can survive anger. It can outlast scandal, but it does not survive observation. Once the plea was entered, something irreversible occurred, not in the courtroom but in the bloodstream of government itself. The system, long accustomed to bending around certain names, stiffened, quietly, deliberately, like a spine rediscovering its purpose. The White House still said nothing. That silence was no longer strategic. It was defensive. Because now every phone call carried risk, every meeting carried witnesses, every word, if spoken, could be subpoenaed into daylight. The walls of executive privilege, once thick with assumption, had thinned to paper. I saw it in the filings that crossed my desk next. Federal observers, oversight requests, interagency coordination memos stripped of ornament and written with surgical restraint. The language had changed. No more hypotheticals, no more deference, only caution. Barron Trump remained in custody awaiting sentencing. He was no longer newsworthy. That alone spoke volumes. The press, starved of outrage, turned its attention elsewhere, but not before planting the final seeds. Could presidential silence itself be evidence? When does restraint become acknowledgement? Is inaction a confession? These were not questions meant to be answered. They were meant to be remembered. Inside the courthouse, I prepared for sentencing with the same ritual precision I had followed for decades. No drama, no speeches, just law. Because anything more would contaminate the record, and the record was now sacred ground. When Barron was brought in, he stood straighter than before. Not proud, not defiant. Present. He had learned something prison teaches quickly. Noise fades. Reality doesn't. Mr. Trump, I said, this court has received no communication from the executive branch regarding your case. Do you understand that? Yes, Your Honor. His voice didn't shake. Do you understand that this court never requested such communication? Yes. A pause. And do you understand why? He swallowed. Because it would be wrong. That was the first true sentence he had spoken since this began. In the gallery, no one moved. Not a sound. Even the cameras seemed reluctant to blink. I looked down at the bench copy of the Constitution, not as symbol but as artifact. Ink and parchment, fragile, enduring only because people decide, again and again, not to tear it. This court sentences you, I said, based solely on your actions, not your name, not your lineage, not the office your father holds. The sentence was measured, firm, humane, unavoidable. 2 years, credit for time served, restitution ordered in full, justice, not vengeance. As the words settled, Barron exhaled, not relief, acceptance. Outside the courthouse, the story no longer belonged to him. It belonged to the absence upstairs in Washington. Because the longer the president remained silent, the clearer it became. He was being advised not to cross a line he once believed did not exist. And somewhere in Congress, Drafts were being written that might never be filed, but would never be forgotten. Chronologies, timelines, chains of intent, all waiting on a single variable, speech. When court adjourned, I returned to chambers and closed the door. For the first time in weeks, the room felt still. Not calm, but resolved. The reckoning had narrowed. The son had been judged. Now the nation waited to see whether the father would test the limit one final time or retreat, leaving history to record that when power met law, law did not blink. History does not announce itself. It waits. For days after sentencing, the country leaned forward, listening for a sound that never came. No proclamation, no executive order, no midnight eruption from the most powerful office on earth. Just restraint. And restraint, at that altitude, is confession by omission. Inside Washington, lawyers did what lawyers do when the ground becomes unstable. They advised silence, cautioned patience, and counted votes that had not yet been cast. The phrase constitutional implications appeared everywhere. Memos, margins, whispered warnings passed between closed doors, because everyone understood the same unforgiving truth. If the president intervened now, it would not save his son. It would indict himself. The file in my chambers thickened with time, not drama. Compliance reports, restitution receipts, corrections intake confirmations. Each document carried the same quiet message. The system was functioning. That, more than anything, terrified those who believed it wouldn't. Barron Trump began his sentence without ceremony. No press, no statements. Just a young man walking through steel doors that did not recognize his last name. The sound of them closing echoed longer than it should have. Not because it was loud, but because it was final. Weeks passed, then months. Congress never opened formal proceedings. It didn't need to. The threat of them had been enough. The silence from the Oval Office remained unbroken, not noble, not gracious, but cautious. A retreat disguised as dignity. And so the crisis ended the way most democracies survive their greatest tests, not with triumph, but with limits respected just long enough. 1 year later, long after the cameras had found other storms, a letter arrived at my chambers. No return address. Handwritten. Careful. Judge Caprio, I am writing this from a place where titles don't matter. I have had a lot of time to think. I was raised to believe power meant immunity, that rules were for other people. You showed me otherwise. You didn't hate me. You didn't fear my name. You just applied the law. That changed everything. I'm sorry for what I did. To Michael Chen, to this court, to the idea of justice itself. I don't know who I'll be when I leave here, but I know who I'm not anymore. Barron, I folded the letter and placed it back in the file, not as evidence, but as record. Redemption, after all, is not a legal finding. It's a private one. Michael Chen graduated that spring, computer science honors. His restitution paid for a new laptop and then some. He never sought attention. He never needed it. Justice had done its quiet work. As for me, I returned to the bench the next morning. Another docket, another defendant, another moment when the air hardened and the law became real again. That is how democracy endures. Not because power behaves, but because occasionally someone refuses to bend. A president's son threatened me with White House power. I answered with the Constitution, and for once, just once, the line held. Court adjourned.